Name, sir? Okay. What are we doing on this one?
Before a single plea is entered, before a single charge is read, this courtroom is already sitting on a powder keg. What you're about to watch isn't just another probation violation hearing. It's a slow-motion collapse of trust between a judge and a defendant who is given chance after chance. This case revolves around repeated alcohol violations, missed breath tests, and a sobriety program that was supposed to be a lifeline, not a loophole. The stakes here are real: jail time, revoked probation, and a judge who makes it crystal clear that dishonesty will not be tolerated. As the counts begin to stack up, listen carefully to the tone of the courtroom, because what starts as routine paperwork quickly turns into a brutal reckoning. The question isn't whether the violations happened, it's whether the defendant ever intended to be honest in the first place. And when a judge feels lied to under oath, the consequences can be swift, severe, and unforgettable. Stay with us, because this courtroom exchange takes a sharp turn you won't see coming.
BT on December 12th of 25. How do you plead?
Guilty.
And that's on the sober link, and that was on December 12th, right?
Yes, sir.
Did you fail to do that?
Yes, sir.
Count two, that you submitted a breath test through a sober link on December 13th with positive results. So that would be failing to refrain from consuming alcohol. How do you plead? Did you fail to refrain from consuming alcohol on the 13th?
Yes, sir.
Count three, that you failed to refrain from consuming alcohol, testing positive again on December 14th. How do you plead? Did you consume alcohol, say again, on that date?
It was within 72 hours.
I didn't ask you that. Did you test positive for that and consume alcohol on the 14th?
Positive, yes.
Count four, to the charge of failed to refrain from consuming alcohol, submitting to a breath test with positive results on December 15th. How do you plead?
Guilty.
Did you test positive that date?
Yes.
Count five, that you failed to submit to a 7 a.m. PBT on sober link on December 18th. How do you plead?
Guilty.
I need Emily in here on this one. Count six, that you failed to refrain from consuming alcohol, having a positive result on December 16th. How do you plead?
Guilty.
Count eight, that you failed to submit to a PBT on December 18th. How do you plead? Count nine, did you fail to do that? Yes.
Yes, sir.
Count nine, that you failed to submit to a 7 a.m. PBT on December 20. How do you plead?
Guilty.
Fail to do that?
Yes, sir.
Count 10, that you failed to refrain from consuming alcohol, testing positive on December 20. How do you plead? Fail to do that?
Yes, sir.
Count 11, you failed to submit to 7 a.m. PBT on sober link on December 21. How do you plead?
Guilty.
Fail to do that? Count 12, that you failed to refrain from consuming alcohol, testing positive for alcohol on those dates in time. That date, December 21, at 9:04, 9:18, 9:48, October 18, October 48. I'm sorry, 10:48, 11:31, and then missed on 11:48. How do you plead?
Yes, guilty.
Did you fail to do that?
Yes.
Anybody forced you to plead guilty? Please are accepted. The counts 1 through 12, with the exception of 7. Count 7 is dismissed. It's a duplicate. I think I need Ms. DeCino to tell you what's going on.
At this point in the hearing, something critical has already happened. The defendant has effectively admitted to a sweeping list of violations: multiple missed breath tests, multiple positive alcohol results, and repeated failures to comply with court-ordered monitoring. In sobriety court, these aren't minor slip-ups, they're red flags. Each missed or failed test chips away at the court's confidence, and collectively, they paint a picture of noncompliance. When the judge warns about up to 93 days of incarceration, that's not a scare tactic, that's the legal reality. Probation is a privilege, not a right, and every guilty plea here tightens the noose. The dismissal of one duplicate count might sound like relief, but make no mistake, the remaining counts are more than enough to justify serious consequences. This is the moment where the case shifts from procedural to personal, and the judge begins evaluating not just the violations, but the honesty or lack of it behind them.
I want to hear.
Yes, Judge, and I don't have the particulars on the hearing that's coming up, but in talking with your judge, he's been pretty direct and candid. He's struggling with alcohol.
He lied to me under oath. He lied to me under oath. I want to repeat what I said. He lied to me under oath. I gave him every opportunity every opportunity to come clean, and you lied to me under oath. You got no business being in sobriety court. We made a massive mistake on this one. What a failure on our part to see through the nonsensical garbage. And I, as the head of this sobriety court, accept full responsibility. You lied to me under oath. You don't lie in a courtroom, son. I don't care what it is. You want to tell me I'm struggling? I'd have been so understanding, it wouldn't have even been funny. You don't lie to the judge, and you don't lie when you're under oath, and you hit both. I feel like terminating him. That's how upset I am with him. I really do. I mean, I'm just ready to go give him 93 days and let's move on. I will not tolerate people lying to the courthouse. Not me. It's not about me. Not about me. You don't lie to the judicial system under oath. You don't do it. I gave him every opportunity to get off the mat. No. It's a malfunction. It's a malfunction. So I got to have people from house arrest take time from their day to come on. We got to spool around with switching out devices. And then the same thing happens. And I'm telling you, if this was a malfunctioning device, not one, but two, he needs to go buy a lottery ticket. He'll be a billionaire by 6 o'clock or whenever the next drawing is.
This is the breaking point, the moment where frustration turns into fury. The judge isn't reacting to addiction alone. Courts understand relapse. What ignites this response is deception. Lying under oath strikes at the heart of the judicial system, and the judge makes that unmistakably clear. Notice how the language shifts. This is no longer about treatment plans or second chances. It's about accountability. The judge openly questions whether this defendant ever belonged in sobriety court at all, calling it a failure of judgment and a misuse of resources. That's powerful and rare. When a judge says they're ready to impose the maximum jail sentence on the spot, that's not theater. That's a genuine warning shot. So here's the real question for you watching. If someone lies repeatedly while asking for help, should the system keep extending grace or draw a hard line? Let us know what you think.
And pretty quickly we got to the point. He has been involved in counseling with the Carol. I'm hoping the court will order that his counseling is increased, possibly intensive outpatient, because he is struggling with that degree and he needs the help. I don't know exactly what's going on with him in his personal life, but he does have a job. He works at the call center, gets off at midnight. He says he's going to be doing his meetings after that. He's working toward getting a sponsor, but he doesn't have one yet. And maybe getting a sponsor would be the part of this that helps make a difference for him. But if he's made a step today that he's acknowledging this, I hope he gets a chance.
Anything else that you want to say, sir?
No. Given this option, I went through.
Anything you want to say?
I am certainly some capacity that I don't think it's uncommon for the early days for people to fight it. I think it is a step in the direction that he was at least honest today. I'm equally as frustrated when I think of the work I put into the other violation. I'm kind of thinking that maybe a scram tether would be appropriate because now we're having an issue that he's missing the 7 and 11 a.m. one. And then I would definitely want to speak to Higuera about getting him into IOP and maybe an MAT consultation. And the ETG did come back and confirm I got it today for the record.
I just don't understand. I just don't understand how when a judge lets you off the mat, and I did let you off the mat, I mean, I told you not to lie to me, and you lied under oath. I get the whole addiction thing. We all get that. Every one of us get that. I don't understand how, when I was talking to you and I knew you were lying, and you kept assuring me you weren't lying, and you testified under oath, I would not blame myself for sending you away today for 93 days. I want to be clear about that. You just got started in this program, and you aren't even giving it a shot. And I get the addiction thing. We all understand that people are going to fail. They're going to relapse. I get it. But you went to such great lengths. I'm going to have a hard time forgiving you for that. I mean, you really went to great lengths. But that being said, here's what I'm doing. You're to serve 10 days jail now. I don't care who you're going to be with or not with on Christmas. That's just too bad. That's just too bad. You're going to serve Christmas Day in jail. And for you to make me do that, for me to do that, you really pushed me. You ought to know that. You're to have a MAT consultation. You're to convert to a scram tether first business day following release. So we can even take the sober length that he's on. I don't know where he got it, if he got it from house arrest. Pardon?
I'll have to take it to house. If he doesn't have it with him today, he can bring
Do you
it.
have it?
I would rather him keep it almost so that when he gets out,
It's going to be,
what if he gets out at 7 p.m. on a Saturday, you know?
that's fine. I'll let you work on that. You're going to return that. We're going to give you a scram tether, 10 days jail, 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. This is basically about it. This is your last chance. You lie to me again, we're done. Good luck. That's what we'll do. And you can talk to Gary about IOP, intensifying the treatment.
That is being for the court.
I do. And we'll see how things go. Thank you very much. People against Bradley Jacob Malott, 25W8384.
In the end, this case lands somewhere between punishment and mercy. Despite overwhelming frustration and clear grounds for harsher penalties, the judge stopped short of the full 93-day sentence, instead ordering 10 days in jail, stricter monitoring through a scram tether, and intensified treatment requirements. The message is unmistakable. Relapse may be understood, but dishonesty will not be excused. This ruling reinforces a core principle of sobriety court. Transparency is non-negotiable. The defendant is left with one final opportunity, and the warning couldn't be clearer. Lie again, and the system will respond without hesitation. Cases like this highlight the fragile balance courts must maintain between rehabilitation and accountability. Back-end index pointing right, if you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.